Commissioner McDermott?
I was told council wanted to see me at sidebar. So if I get frustrated at lawyers about something, I try not to, and I don't think I can, but if I seem to cut somebody short, the lawyers are just doing their job. When they request sidebar conferences, they're just doing their job. I am going to try and keep all sidebar conferences to a minimum, but the lawyers are just doing their job. Okay. All right, go ahead, Mr. Leslie, if you're a witness.
I just need a witness. Yes. Certainly.
Afternoon, Your Honor.
May I, Your Honor?
Yes.
Good afternoon, Ms. Hyde.
Good afternoon.
I notice you have some documents with you. Could you just state what is in front of you so I know that I might be able to help expedite this if I know what you have in front of you?
Absolutely. I have the first digital forensic analysis report I completed for the previous trial.
Do you have a date? You have several of them.
I do. It's the first one. I apologize. Second one, this was the one that was used in the pretrial motion.
December 2024?
December 20, yes, that's correct. Very nice. Then I have the third one. This is the final one regarding the phone that was identified as Ms. McCabe's.
Yes.
And then I have the fourth one, which is the phone of Mr. O'Keefe. And then I do have the opinion from State versus Huera, but if we don't need that, that's fine.
Okay, very well. I appreciate you telling me that. In March, and you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial in the state of Maryland in a case called State v. Herrera as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And in that particular case, you had attempted to offer various opinions to the court, correct?
I object.
You have to move along from this case, from what you're talking about. You have to move along from that Maryland case.
So with regard, do you recall another case from the state of Massachusetts, Arrington case, in which you submitted a pro se amicus? Do you recall that case?
I do.
And is it correct that in that case you submitted arguments on behalf of the prosecution in that case?
I submitted an amicus brief, which is not on behalf of anybody. It's as a friend of the court.
Right, but the Friends of the Court, you took a position in that, quote, Friends of the Court brief, correct?
Took a position on the evidence.
Right, and the position you took on the evidence was that the frequent location history data is reliable and should be used. Is that correct?
The statement is that I do not have that amicus in front of me. It has been a year and a half since I've read it. But that amicus does discuss frequent location history records, and I want to be clear, it speaks to both bias on both sides and negative and positive of submitting it. It was an unbiased writing, and it was not specifically in support of the prosecution.
So you are testifying in this case on behalf of the prosecution, correct?
In this case, I was hired by the prosecution.
Right.
That's correct.
And the prosecution is paying you for your services in this case, is that correct?
Yes.
And with regard to this case, you have been paid and have been on this case since May of 2023, correct?
That is correct.
With regard to the various reports that you have submitted in this case, you have mentioned one which is a report with regard to the iPhone of John O'Keefe. Is that correct?
That is correct.
And you have, in that report, you have made a statement, have you not, that from 12:20:50 a.m. on January 29th of 2022 and after, there is no indication of interaction with the device. Is that correct?
There is no indication of user interaction with the device. There is all received until about 6:04 a.m. when there is again Apple Health data that picks up.
I'll ask it again. And you can feel free to turn to page 1529 in that report.
Page 15?
Page 1529.
The report is
Would you like the
50
page of the report or the page NDA number at the bottom? I can do either way.
Oh, I'm sorry. I thought you were saying page 15 in the report.
No. It's
I
NDA
apologize.
1529 or page 7, whatever way.
Page 7. Okay, Roger.
Okay, so page 7, you see there's a heading interactive phone activity, correct?
Yes.
And at the top it says, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20.
Yeah, you have to
Slow down. Okay, sorry about that. I'm just trying to move it along, but I will be slower. I'll repeat. Using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20:50 a.m. ET. You see that statement?
Yes.
And that if you skip down, I'm going to skip a couple sentences to the paragraph under the chart, and this is the key part.
Okay.
It says, from that point, and I'm understanding that point to be the 12:20:50 a.m., correct? You need to say yes or no, I'm sorry.
Yes.
There is no indication of interaction with the device. Did I read that correctly?
That is correct.
So I am going to, and you believe that statement is correct?
Until 6 something a.m.
No, I'm sorry. I'm just asking if that statement is correct. Not if you have other information, but is that statement correct?
I object.
Can you answer that? Who's I? Can you answer that, yes or no?
Did I read that correctly?
You read it correctly,
Thank
yes.
you. If we could, Your Honor, have a document that is put up already in evidence and publish Exhibit 39.
Okay.
And it will be, thank you. And if we could go to slide 82, please. And Ms. Hyde, if I could draw your attention to the entry that is, it says 3209 under app lock, but we know that the 00 is a 12. So it's 12:32:09 a.m. on January 29, 2022. And I'm going to read what it says in red, and this is a timeline of Mr. Whiffen. You know Mr. Whiffen?
I do know Mr. Whiffen.
And so he put in red, not us, he said device locked with lock button for the last time. Do you see that?
I do.
And you know that to lock a phone, you actually have to hit the side button with regard to an iPhone to make it lock. Do you know that?
Yes, sir.
Okay. And that is an interaction with a phone, is it not?
I concur.
So that means that that interaction with the phone occurred at 12:32:09, correct?
I did not review that specific artifact. I cannot attest to Mr. Whiffen's exam, only to my own.
So do you have any reason to believe that what is in evidence in this case that Mr. Whiffen has produced, and that do you have any basis to contest the fact that the device was locked with a lock button for the last time on the phone of John O'Keefe at 12:32:09 as you sit here?
I cannot contest it because I do not recall looking at that specific artifact.
Don't you think it would have been appropriate to be accurate?
Yeah, I'm not fully prepared for this yet. I don't know if this is what being stoned feels like, but my brain, it feels, I don't know, slightly disembodied, and like there's a barrier, and like my mind is empty, but not in a good way. And hearing her talk, it's yeah. I don't know what's going on. My mind is not ready for this level of whatever is going on. Yeah, it feels like my brain can't like process information. It kind of feels like a net around my mind. Yeah, kind of feels like a net around my mind. And inside the net, things are dying. Yeah. I don't like this feeling very much. It's not fun for Uncivil. I'm going back to being on strike.
Accurate as a digital digital forensic analyzer on the topic of the last, of an indication of interaction with the device, don't you think it would have been appropriate to look at that 123209 in any of the tools you said you used on direct?
I did not correlate that artifact in my timeline.
I understand you did, and my question is, you make a statement. Well, let me back up. Do you understand that in this case, as in many cases, that matters of seconds in activity can be determinative of a case? Do you understand that from your experience?
Absolutely.
So it's important, therefore, to get activity right for any data forensic examiner when they're issuing reports about activity, particularly of a decedent. Is that important?
Absolutely.
So isn't it correct that the statement that you make on page 7 of your report?
All right, so we just need to clarify. This is not different from anything I said earlier before the break, but we just need to clarify exactly what my current legal position is on these issues, which, again, I am willing to have a conversation with another lawyer because I could be mistaken on this point. But there are there's at least 3 distinct concepts here I want to clarify. And this is not inconsistent with what I said before, but I just want to clarify my current thinking. With respect to whether or not she can be asked sort of the ultimate question, isn't it true that the Maryland court found that you're a dum-dum? My best legal opinion at this time is that the judge is correct to not allow that question to the jury, in front of the jury. So that's position number 1. As to whether or not that Maryland decision is competent evidence the judge should use, among other factors, for a Doe-Bear analysis that would suggest this woman is not competent to testify, then yes, it is competent for that purpose. And issue number 3, is this woman a fucking idiot? Yes. So hopefully that's clear. So, okay.
That from that point, 12/20/50, there is no indication of interaction with the device is incorrect.
I cannot make that without going back and reviewing and validating the artifact you just produced from Mr. Whiffen. I would need to validate that in order to respond to that.
But as you sit here, you have no basis to contest what Mr. Whiffen has stated, that there was a lock button on the side of the phone of Mr. O'Keefe a full 12 minutes after you say there was no interaction with the device. Is that correct?
I don't. I would have to review that portion.
Is there anything that had prevented you from reviewing that in that data before you wrote this report?
Not that I can think of. I would have to go and re-review that.
My question is...
I don't know if that artifact, I have not reviewed that artifact, so I cannot speak to an artifact I have not reviewed, and I did not, that is not my report, that's Mr. Whiffen's report, so I cannot speak to that without going back and reviewing that evidence.
Isn't the interaction with the device, a lock button, readily available to you in the data that you have and had in your possession when you wrote this report?
Yes.
Thank you. If you could please turn to, in the same report, page 1528, which is your page number 6. And I just want you, please, to go to the, just put a placeholder in that. And if you could now just go to the conclusion, which is your page 50, 50. Let me know when you're there.
I'm there.
So in the conclusion, you state that starting at 12:01 a.m. on January 29, 2022, the mobile phone was in use with activity of Waze navigating to 34 Fairview Drive, Canton, MA, active interaction with the screen, steps, audio playing, text messages and calls until 12:31 a.m. EST on January 29, 2002. Did I read that correctly?
Yes.
That statement is also incorrect, isn't it?
On what basis?
Do you believe that statement is correct or incorrect?
I believe that the statement is correct regarding those artifacts that are mentioned in that statement, yes.
Okay, if you could please, turn to page 1535 of the same report.
Can you give me my page number, please?
I will.
Okay, thank you.
You're welcome. If you could turn to your page 13.
13, Roger.
Did she just say Roger?
And you see
What the fuck?
it says 12:31:56, which is the same time in the conclusion, but I'm going to develop it.
I believe I know where you're going.
Well, hold on. I'm sorry. I need to ask the
apologize.
questions.
Yes.
I appreciate you looking to help, but if I could, I'd appreciate it.
Absolutely.
Steps, and it has steps 36, duration 20.9 or 20.398 seconds. Did I read that correctly?
That is absolutely correct.
So if you look at this data point in your report on page 13, the steps began at 12:31:56, but they...
All right, what problems are you having with the volume now? You'll have to be more specific. Oh, my volume's too loud. That's the problem. Sorry, I adjusted the wrong volume the wrong way. Okay, Kurt was a moron. He shifted the volumes the wrong way around. Kurt made a mistake. He put his audio loud and the court audio soft. Kurt made a mistake. Kurt was a dum-dum. Kurt apologizes for the error. Kurt is uncivil, is hurting, and numbers are confusing and stuff. Sorry. Oh, sorry. I fixed it. Sorry, my bad. Sorry, my fault. I fixed it. It's better now. Okay, I'm going back to being on strike. It's still loud. It shouldn't be. My volume's at 80% relative to. Yeah, it shouldn't be. It should be a lot better. It's down. It was at 120. Now it's at 80. It should be a lot better. Okay. Yeah. Sorry. It hasn't changed. So loud. I don't know. It's at 80. It should be fine. I don't know.
ended 20.39 seconds later at 12:32:16. Is that correct?
That is correct.
So therefore, your statement in your conclusion, if you could go back to 50, and this is in your conclusion, your statement there is that the steps, the mobile phone is used with activity, including steps, until 12:31 a.m. EST. That should read until 12:32:16, correct?
It depends on your interpretation of interaction. As a user is walking, they're not actively interacting with their device. It's their movement that is. It's not direct interaction with the screen. But I would agree to your view that that could be interpreted as needing an additional 20 seconds.
Isn't the more correct way to state the conclusion that the active interaction when it comes to steps is not calibrating using the screen, but the phone is calculating steps taken? Isn't that correct?
That is correct, but that's not interactivity with the device.
I understand, but
Yes.
the sentence reads, includes steps, and the more accurate way to have stated that would have been to put 12:32:16 instead of 12:31 a.m., correct?
I'm sorry, you just said 12:30. I did this to the minute, not to the second. Could you rephrase what you were citing?
Well, I'll state it again.
I appreciate that.
You're welcome. So isn't the more correct way to state this important data point in your conclusion, instead of saying active interaction with the screen and steps, etc., until 12:31 a.m. EST, the 12:31 should be 12:32, because the steps that you have on your page 13, by what you conceived, is the duration of 20 would have brought it to 12:32:16, correct?
I would state that depends. I believe either is a correct way to state that. Based on interactivity, based on your interpretation, your definition is more correct.
Okay, thank you. And it's not my interpretation, I'm reading from your report, correct?
Your interpretation that 1232 is a more correct representation of interaction is based on your theory that interaction concludes when the steps end. And I'm saying both would be acceptable.
Okay, so let's follow up on this.
Sure.
Isn't it correct that it isn't my theory when the steps ended?
Oh, it's not,
If I
agree.
could just finish,
Please,
because if
absolutely,
we
sorry.
talk over each other, the stenographer's not going to get both of us. Thank
Agreed.
you. So it's not my theory, it's just the simple math from an entry you've made on page 13 that the steps began at 12:31:56. They ended 20.398 seconds after that, which, just doing the simple math, is 12:32:16. Did I do the math correctly?
That is correct.
Okay,
I'm not
thank you.
debating that.
Thank you very much. So now what I'd like to do is to go to page 1528 of your report.
Do you have my page number for that? I'm sorry.
Yes, and I appreciate that you go page number, so I just center in on the lower one, then I'll go immediately to the one. So it's your page 6, Ms. Hyde.
Thank you.
You're welcome. Just let me know when you're there.
I'm there.
If you could please go to Apple Health Data Steps. And we've been talking about steps because they're important enough that you put them in a report, correct?
That is correct.
So let's go to an important data point, therefore, in your report, in the chart, which is the second entry, which is, as you've stated, 12:21:10 a.m. Do you see that?
I do.
And you note under the data that John O'Keefe's phone registered 80 steps at 12:21:10. Did I read that correctly?
You did read that correctly.
And those 80 steps constituted 191.253 seconds, as you state, correct?
That is what is stored in that database, correct?
And is my math correct, so that the jury understands this perhaps a little better?
Sure.
That 191.253 seconds equals 3.2 minutes,
Approximately, yes.
approximately.
I'm doing the math in my head, so that's why I said approximately.
Right. Understood. So am I reading this entry correct, that you're stating what the data shows, that 80 steps were taken by the phone of whomever had the phone of Mr. O'Keefe? There were 80 steps taken at 12:21:10 a.m. on January 29, 2022, for a length of time of 3.2 minutes.
That is what the phone registered.
That's what the phone registered. Very well. Now what I'd like to do is to turn to the phone of Jennifer McCabe.
Okay.
And that is for your reports. You don't date your reports, so I can't give you a date, but it
I know,
says...
it's report 3, I believe, is what you're looking at.
Exactly.
Yep.
It's 3. And there is... Bear with me, I'm accommodating your page reference, and I'll have it soon for you. It is your page 7. And let me know when you are there.
I am there.
Are you aware of an issue regarding the time of an interactive phone activity on Jennifer McCabe's phone at 5:07 a.m.? Are you aware of that issue, and particularly a communication to a person named Coco? Are you aware of that?
I would need to check in my report. May I turn to the page for
Absolutely.
that time?
And
I
if
do
it
see
is-
an outgoing call to someone labeled Coco at 5:07:21 a.m.
And you can tell that because in your report on page 11, you list a 5:07:21 a.m. call to a Coco as outgoing, correct?
Correct.
Have you discussed that call with any member of the Commonwealth?
No.
And again, this call is at 5:07 a.m. on January 29th of 2022, correct?
That is correct.
There is no duration listed for that call. And if you just follow my questions, if you can, yes or no. Is that correct? There's no duration yet listed.
Correct.
So what I want to do is to also note that that omission is not the only omission of durations from this report, or I'll state it differently, let me withdraw that. There is no population of the duration column for any call from 12:14:30 a.m. on January 29, 2022, all the way through this 5:07:21 call, and you don't start listing durations until 8:59:34 a.m. Is that correct?
Yes, and explainable. The artifact.
I understand
Yes.
Mr.
Okay.
Brennan can
Sure.
handle those on his redirect.
Absolutely.
So there's not a population of duration of calls after numerous early calls and phone, as you call it, interactive phone activity. Nothing populated in this report until 8:59:34. That's correct?
Yes.
All right. Now what I'd like to do is to turn to the 22740 artifact that was the subject of much discussion on direct. And I am going to refer to that as an artifact. Is that a parlance that is familiar to you?
Yes.
And if I refer to that as a timestamp also, is that a parlance that's familiar to you?
Absolutely.
So I can refer to 22740 as a timestamp, and you would find that parlance acceptable.
Yes.
Thank you. So I'm going to do that. Just to keep it simple, I'm going to refer to it as a timestamp. Now, you've been on this case working for the Commonwealth since May of 2023, correct?
May 4th, 2023. That is correct.
So you've been on this case for 2 years, correct?
Not actively the entire time.
But you started on this case in May 2023. You issued a report in May
Correct.
of 2023, correct?
Correct.
You issued a report in December of 2024, correct?
Correct, after being rehired in November.
Right, and you issued more reports in 2025, correct?
That is correct.
So all of that activity has been on this case, correct?
All on this case, that
And
is
that's
correct.
been all on behalf of the prosecution, correct?
That is correct.
None of that work has been done on behalf of the defense, correct?
That is correct.
So let us now go to the timestamp of 2/27/40. Your opinions on what is the meaning of that timestamp have varied from May of 2023 until today. Is that correct?
No, that is incorrect.
Let's cover that issue.
Sure.
Let's turn to your May 2023 report. Isn't it correct that the report and your findings were pursuant to a request from Detective Lieutenant Brian Tully?
Correct.
Did this woman testify at the first trial? Because I'm honest to God drawing a mental blank. I don't remember her. Did she testify the first time? I don't remember her. I don't remember. Does any by Zoom? She testified via Zoom. Oh, maybe that's why. Oh yeah, I don't remember this woman. I got nothing. I got nothing. I got no memory of this woman testifying via Zoom or otherwise. I got nothing. There's just a big empty space in my head. That's disturbing. That's very disturbing. Yeah. Okay, I'll take your guys' word for it. I mean, I sat through that entire trial, and like, I just don't remember her at all. My memory sucks, apparently. Her turban was purple. I don't remember that at all. I got nothing. I got nothing. My mind is a big blank nothing. She was in the courtroom? I don't remember. I got nothing. I got absolutely nothing. Yeah, I have absolutely nothing whatsoever. I got no memory of this woman at all. That is incredibly disturbing, man. That is unbelievable, man. I thought my memory was decent, man, but I got zero memory of this woman. Holy shit.
And how many interactions have you had with Lieutenant Detective Brian Tully on this case approximately?
I really don't know. I'd have to go look back at email and call logs.
Is it more than 5?
Yes.
Is it more than 10?
Yes.
Is it more than 20?
I don't know.
So somewhere between 10 and 20, would that be fair?
Again, I'd have to review my call logs. I'm not
But it
going to
was
test.
more than 10.
More than 10, I'm sure.
So the issue was your use of various forensic tools that revealed a timestamp, 2:27:40 a.m. timestamp on January 29, 2022. Is that correct? Is that a fair characterization of an issue you looked at?
Correct.
So if you could go to page 5 of that report. And I would ask that you go to the last paragraph that starts with "in the instance of the Google search," and let me know when you're there.
I'm there.
So it reads, "In the instance of the Google search, house long to die in cold, that was recovered from the write-ahead log associated with the X browser state DB SQLite database with the timestamp of 2:27:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
Fair. Yes.
So you use the words that Google search, "House Long to Die in Cold," was associated with the timestamp of 2:27:40 a.m. Isn't that what your words are in this report?
In that database, they are associated. That is correct.
Right. And in terms of page 3, if you could go back, of your report, under relevant findings. It starts with, there were 2 searches of interest that took place on the iOS device, and we're talking about Jennifer McCabe's device, correct?
The device that was identified to me as Jennifer McCabe's, yes.
That's identified to you as Jennifer McCabe. And it's what you talked about on direct examination as her device,
Absolutely,
right?
yes.
It's not a mystery as to whose it is. It's not like you don't know, right?
In direct, I also use the phrase identified to me as Jennifer McCabe's.
Right, but your conclusion is the device you've been working on and analyzing for 2 years is the device of Jennifer McCabe.
That is how it was identified to me.
Do you have a different conclusion as to whose device it is?
I always am very, very careful that I did not assess the ownership. That was information that was given to me, not information that I personally assessed.
So are you uncertain as to whether the device you've been working on for 2 years is the phone of Jennifer McCabe?
The device that I've been working on for 2 years is the device that was identified to me by the Massachusetts State Police, Detective Tolley, as belonging to Jennifer McCabe when I began working and received that device, as stated in the evidence analyzed section on this same page.
So let's go, and we're talking about, again, to get back to the center of gravity, we're talking about a timestamp of 2:27:40 a.m., correct?
That is correct.
And when you issued your first report in May of 2023, the timestamp you were looking at was 2:27:40 a.m.
Okay, Kurt would once again like to apologize for being a complete idiot with the audio. That is the second time that was just completely my fault on the audio levels. The audio was low on the YouTube feed itself. So that's why it sounded low to you, because the feed audio was low. So that is just the second major audio screw up by me today. Kurt again apologizes for the error. Kurt is full of dumb. Hopefully your Kurt will return to you at some future time. I apologize for the error.
January 29, correct?
I was looking at multiple timestamps associated with the same 2 searches.
Right. So what I'd like to do, you said multiple timestamps. What times are in the multiple category?
What I was tasked to do was to look at the times, the search, the Google search history, I'm sorry, not Google search history, the Safari history, which includes Google searches, associated with those 2 search terms within that 12-hour period. That was the particular task, not the task of looking at the 227, just for clarity.
Right, and I appreciate that, but my question wasn't that. My question was, I thought I heard you on direct examination, which is why I repeated the question, what I thought I heard on direct, but I'll ask you the question.
Sure.
You looked at and talked about on direct 2 potential times for a Safari search, which includes Google, one of which was 2:27:40 and the other one was 6:23 a.m. Is that correct?
I analyzed the meaning of those 2 timestamps.
Right, so we're just talking about 2 times, 2:27:40 and then 6:23. Is that correct?
So you are only talking then about the one that we're also talking about 6:24 a.m.
Okay, so we got
Eastern time for clarity, because some of these records are in UTC, some are in local.
Fair enough. So you've got 2:27:40, you've got 6:23, and you got 6:24 that you were looking at, correct?
There are other timestamps that exist in the realm of what I was looking at, but those ones, correct, are the ones that are relevant in this report.
Exactly. And that's what we're talking about.
Okay,
We're just talking about this report.
Yes.
And so if you look under relevant findings, at the very bottom paragraph, you say, second sentence, a Google search for how long to die in cold at approximately 11:23 a.m., and then how long TIDIE in cold took place at 11:24.
That is in UTC. I apologize for not having the time stamp format there, but that is the UTC time. The UTC time equivalent in Eastern Local Time would be 6:23 and 6:24.
So to be clear, in your report, you wrote 11:23 a.m. and 11:24, and you didn't put UTC next to it,
Correct.
did
They
you?
should. You are correct. That should say UTC. That is a typo.
And there's a significant difference between 11:23 and 2:27:40, correct?
11:23 is UTC, so its equivalent in Eastern Time would be 6:23. The artifact of 2:27 is already in local time, so that is in Eastern Time. So what we would be comparing is 2:27 and 6:23 and 6:24 to be appropriate. They're taking into account the data storage and which ones are in UTC and which ones are in local time.
I understand your explanation now.
Perfect.
But in this report, there is no UTC time down. You have two additional times in addition to the two times, two different numbers added to the two, correct?
The UTC was a typo. It should say UTC next to those, and the chart shows all of those artifacts in EST and is clearly labeled that they're all in EST.
So you would agree that it's better stated to state it a different way than you have in your report?
I would say that both are equivalent. I should have had UTC there. But yes, it's easier for the audience to speak in EST. I would say forensics examiners typically communicate in UTC, but we translate for our reports. And I should have either communicated that in EST or included UTC. I will definitely contend that.
So in terms of your May 2023 report, your first report in this matter,
Yes.
you on page 5, in the sentence underneath the block paragraph state, in the instance of the Google search, how long to die in cold that was recovered from the write-ahead log associated with
That's correct.
the X browser stage with a timestamp of 2027:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
You read that correctly.
Now let's move ahead to page 7 of your report. Up at the top above conclusion. Importantly, at this time, you state, testing shows great inconsistency with timestamps parsed from this file. It is, however, definitive that the page existed in a tab.
Correct.
While a definitive reason as to why the timestamp is listing the time of 2:27:40 is unknown, the time is inconsistent with the timestamps associated with the same search. Did I read that correctly?
You did read it correctly.
So as of May 2023, you said the definitive reason as to why the timestamp is listed as 2:27:40 is unknown, correct? I'm just asking, is that what you wrote? Unknown.
I believe that the wording here is, sorry, I know I do use the word unknown. It says, while a definitive reason as to why the timestamp listing is the time of 02/27:40 is unknown. Sorry.
So you use the word unknown, your word in your report.
Yes.
Okay, so now what I'd like to do is to go on to the first proceeding in this matter. Do you remember giving testimony in a proceeding about a year ago under oath?
Yes, I do.
I am now going to go to that testimony and If at any point you would like to have a copy of that, if it's the honor, if Your Honor would like, I will do it, but I'm going to start and then we'll see how it goes. So, bear with me a moment. Do you recall in that testimony stating that you processed the image in several forensic tools? I use Celebrite Physical Analyzer, and then you list many other tools. Do you remember giving that testimony?
We have a page.
I'm sorry, Mr. Brennan, I thought I'd given it 1-12. My apologies if I didn't. It's June 14, 2024, page 1-12.
Thank you.
You're welcome. So, do you recall giving testimony about the various tools you used for this timestamp?
I do.
And do you recall stating that those tools were commonly used digital forensic tools that are very standard? Do you recall that?
I'd have to see the wording that I used at that exact time.
Would it be helpful to refresh your recollection if I showed you that?
It would be great. I would greatly appreciate that because I do not recall the precise wording, but I know that I
Fair
spoke to the
enough. I'll
tools
get
I
that for
used.
you. May I approach, Your Honor?
Yes, Mr. Alessi, you offered a transcript. Do you have the whole
I have the
transcript?
whole transcript if that helps.
It might speed things along.
Agreed.
Okay.
We have one out provided. Ms. Hyde, I'm going to leave you a transcript.
Thank you. I appreciate it.
So, may I approach, Your Honor?
Yes.
Thank you. Mr. Brennan?
112. Thank you. You are. That's, let me turn it over to, it's going to be 112. Okay. Go to it. Yep. Thank you. You're welcome.
Thank you so much. And you said we're on 112?
Yes, please.
113, I see it. I see it's highlighted on the copy, so I figured that's the
what I
one.
wanted to do, the reason I said 112 is that's where I
Oh,
started with my
sorry.
previous question. So I'm not going to repeat the question, but just to orient you, so you have a fair context for the questioning.
Fair.
So I started at the bottom, 112, now I'm moving to 113, and I'm starting with line 7. Do you see that?
I do.
And it says, yes, they are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. Did I read that correctly?
That is correct.
And then if you go down to line 22, you testified in that proceeding, so it's important to use multiple tools so you can see the results from different data sets, and be able to compare those results and enhance those with manual analysis. Did I read that correctly?
You did. That's correct.
And then going up to page 114, line 5,
Slow down a little bit, Mr. Alessi.
I will, Your Honor, thank you. Yeah, that's very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretation from forensic tools. Of course, you go beyond that with your analysis, but it's absolutely pertinent to that. Did I read that correctly?
That is correct.
And then lastly, for this section at page 114, 17, the Sanderson tool is meant to look at specific type of data structures called the SQLite database. XQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Did I read that correctly?
Yes, you did.
Thank you. Now if we can go to page 124 of the very same testimony. And feel free to go back a page just so you can see to page 123 that the topic is the 2/27/40 timestamp associated with house long to die in cold. Do you
Can I
see-
have a moment just to review and get context?
Absolutely.
Thank you so much.
Page 123:13, but if you need to go back further, feel free.
Okay, I'm good. Thank you.
You're welcome. So what I want to do is start with page 1-23, and this is your testimony. On line 16, I have them in the timestamp order that is associated with the artifact. You use that word associated again, correct? Did I read that
Correct.
correctly?
Yes.
And that's associated with the Google search, House Long to Die in the Cold, in a 2:27:40 a.m. timestamp, correct?
That is correct.
Now if you turn the page of the testimony, you state back then that on page 124, line 1, the browser state DB is an artifact that speaks to when tabs are moved. So when you're using your browser and you open different tabs, you may have a search that this time pertains to the time that the tab moved. It could be lots of things. Did I read
Correct.
that correctly?
You did.
Not one thing, you said it could be lots of things, correct?
That is correct.
And then you go on in line 10, and you talk more, and then you go down to the bottom. You go down to line 20, and you testified, we cannot tell by this particular artifact what time that search occurred. Did I read that correctly?
It's specifically pertaining to that particular artifact that in browser state DB that does not tell us what time a search occurred. That is correct.
Right. So you stated, and it was your statement then, we cannot tell by this particular artifact what time that search occurred, correct?
That particular artifact.
Okay, so now let's keep going. If you go to page 129 of this transcript,
I'm there.
at the top,
Sure.
line 1, 227 isn't necessarily one time when the tab was closed. That's in my report. I say it's undetermined. Remember we were just reading your undetermined
Absolutely.
in your May 23 report?
Correct.
Because there's a lot of things that can cause that timestamp to be there, including tab being moved, tab being minimized. The next sentence. I don't know exactly what caused the tab to get that particular entry, but it's not, that timestamp is not indicative of the time of the search or any URL that's visited. But the first part of it is, I don't know exactly what caused the tab to get that particular entry. Did I read that correctly?
You read 100% correctly.
Thank you. Now if we could turn to page 130 of your testimony.
I need to object.
I'll see you both.
Thank you for your patience, Ms. Hyde.
Absolutely, sir.
What I'd like to do is to go back to your testimony in the first proceeding, and we can go back to page 1-30.
I am there.
Thank you. So I am going to go back just because there's been some time and give some context. So we're talking about the 2:27:40 a.m. timestamp, correct, at this page location?
We've been talking about that for several pages. Yes, that's correct.
You're absolutely correct. We've been talking about it for several pages. And bear with me, I think this
No
may
problem.
be either the second to last or the last. So there you testified with regard, this was when you're referring to an artifact. You've agreed that timestamp is a fair synonym. You say on line 5, that means it wasn't in the regular database, it was in the write-ahead log. And to Celebrite's credit, that tool actually parsed the write-ahead log and displayed it where the other tools did not. So did I read that correctly, number one?
You read it correctly.
So am I correct that here what you're stating is Celebrite was actually showing the 2:27:40 a.m. timestamp at that time during your testimony in the first
On
proceeding?
that date, that is correct,
Okay,
yes.
so I just wanted to establish that, and you were giving
Absolutely.
Celebrite credit for actually showing that timestamp at that time of 2:27:40 at the time of your testimony back in June of 2024, correct?
That is correct.
Okay, so now let's go to page 1-36.
136, you said?
136, yes.
Thank you.
And on line 12, you note that so Celebrite and Magnet Axiom, and then you elaborate, both Celebrite Physical Analyzer, which is a specific tool, right, of
Correct.
Celebrite, and Magnet Axiom, another specific tool, correct?
Correct.
Both have file system viewers that then have SQLite database viewers. And you, skipping down to line 17, you talk about they don't allow for deep analysis of the write-ahead logs, which is why in my analysis I use the specialized Sanderson forensic browser for SQLite, correct? I read
That
that
is correct.
So is it fair to say that what you did up to this point in June of 2024, with regard to the 2:27:40 a.m. timestamp on January 29, 2022, you applied a variety of tools to analyze the issue of when did the Google search occur, that you use the words associated with a Safari Google search, house long to die in the cold?
There's a little bit of wording I would correct there if that's okay.
Right, but so let me see if I can ask the question
That'd be great.
a different, more simple way.
Thank you.
You're welcome. So you used a variety of tools to analyze that house long to die in the cold search, correct?
Plus manual analysis and testing, yes.
Plus manual analysis and testing. Alrighty, now let's leave the testimony
Okay?
and let's go to your next report. And your next report is December 2024. Do I have
I have
the
it correct.
chronology correct, Ms. Hyde?
That is correct.
So in December of 2024,
Mm-hmm.
just approximately 6 months ago, you issued another report, correct?
That is correct.
And you got the request for that report also from the Norfolk District Attorneys, correct?
That is correct.
And you state in regard, well, that report regarded the analysis of the same timestamp, correct?
Correct.
To 2:27:40 timestamp. And in that report, under relevant findings, you state, and this is December of 2024, so it's from your May 2023 report, it's approximately a year and a half, is that approximately from your May 23rd report?
Approximately.
Approximately a year and a half?
Yes.
So a year and a half after what we just reviewed in your May 23rd report, and then just months after the testimony of June, right? So about 6 months after your
6 months later.
June testimony that we just went through, you went and looked at this issue again, correct?
That is correct.
And isn't it correct that when you were asked to look at the same timestamp in December of 2024, that Celebrite removed the timestamp from their tools?
Celebrate.
Jessica Hyde is an experienced forensic examiner in both government and commercial sectors, having worked as a contractor providing forensic services to the Department of Defense and intelligence community. What the fuck? She currently serves as a consultant to Magnet Forensics, where she was the director of forensics and is the adjunct professor teaching mobile forensics in the graduate program at George Mason University, where she achieved an MS in computer forensics. Jessica is the host of Cash Up, a weekly podcast where she interviews digital forensic practitioners. Kill me. She's also involved in several community efforts, including as a volunteer for the Marine Corps Cyber Auxiliary, chair of DFIR Review, first vice president of the New York Metro High Tech Crime International Association chapter, advisor board for Cyber Sleuth Lab, and a member of the editorial board for the Forensic Science International Digital Investigations Journal. Her previous roles include performing forensic examinations as a senior mobile exploitation analysis for Basis Technology, senior at EY, and senior electrical engineer at American Systems. Jessica is also proud to be a veteran of the United States Marine Corps. This woman is a Marine? How? How is that possible? How can this woman be a Marine? How is that possible? This woman is a Marine? How is this woman a Marine? What the fuck?
It did remove that timestamp from the tool. That is correct.
Okay. And that timestamp was the subject of extensive reports and testimony that you participated in the first proceeding, correct?
That is correct.
And even though that timestamp, 2:27:40 a.m., that showed up in Celebrite Tools, Magnet Forensic Axiom showed up, that was removed by Celebrite, correct?
Celebrite no longer reports it. The evidence
What
is
the
still in the
fuck?
data. I want to be clear, just that it doesn't change the data. They just removed it from their automated parsing and reporting.
Right, so they
Correct.
removed it from their automated parsing and reporting, correct?
Yes, they did. That is correct.
Avionics technician. 6 years
However,
in the Marine Corps. What the
Your
fuck?
former company, Magnet Forensic Axiom, still shows it. Yeah.
Magnet Axiom Forensics currently shows it as a carved artifact and still shows that and gives a description in their artifact reference guide as to what they believe causes that artifact.
I'm going to ask the question.
Yes, it does.
Magnet Axiom Forensic, where you used to be the director of forensics,
That is correct.
still shows that timestamp, right?
Yes, yes,
But Celebrite doesn't in the automated
that is correct.
tools.
That is correct in their automated parsing.
And you would agree that Magnet Forensics is a very reputable company, correct?
Correct.
What the fuck?
Let's go back to your December 2024 report. Do you recall just moments ago when we went through your testimony in June of 2024 in the first proceeding, where you stated various times how it was, I'll use the term best practices, to use multiple tools to analyze the timestamp?
Correct.
And you used many tools back then to analyze that timestamp. And you testified to those many tools on your direct examination, correct?
Correct, yes.
However, in December of 2024, when you returned to analyze the 2/27/40 timestamp, how many tools did you use to analyze that timestamp? Can you give me just a number? How many tools?
At least 4.
Well, in your report, let's go to your report, what your report says. So in your report, you state that under relevant findings, do you not, that review of data from Celebrite shows that the artifact of a Google search from a Safari suspended state tab with the search term house long to die in cold, and I'm going to skip over, in addition to my own previous report, no longer shows a last visited timestamp.
I think that is not clear. The skipping there makes it sound like my report no longer shows that, and that's not what's.
I would never have Marine on my bingo card. Ever. Marines tend to hold themselves, in a more squared away fashion. She served 6 years in the Marine Corps. How is that possible? How's that possible? She served 6 years in the Marine. How's that possible? The woman has no self-confidence. She has no presence. How she served 6 years? How's that possible? I don't know. No, I don't know how. I don't know what's how. I don't know how. I have a pretty high respect for the Marine Corps. They tend to be, fairly squared away people. They tend to be pretty like, what would you say? They tend to be, squared away for lack of a better description. How this woman isn't squared away. She has no confidence. I don't know how. How can this woman be in the Marine? How'd she make it through boot? Unbelievable.
That's a fair statement. That's a fair statement. Let me rephrase it this way.
Thank you.
You're welcome. In this report, you speak about Celebrite release.
I mean, between the two of us, if you had to take money on between the two of us, which one of us was more likely to have served in the Marine Corps? I know I'm no prize, but shit, man. Christ.
Release reports, correct?
Are you referring to the Celebrate release notes
The
that come out?
release notes at the bottom,
Perfect.
right? You
Yep.
referred to that?
That's correct.
And that release note states that Celebrite has removed the timestamp value from records, and I'm assuming that's a reference to Celebrites.
Celebrite no longer parses that result. That is the statement in this report. Correct.
Right. And so I'm going to go to page 4 of your report.
For sure. I'm there.
Maybe I should have been the Marine. Maybe I should have joined the Marine Corps. Apparently, it wasn't that hard, man. Shit. Right. Maybe I should join the Marines. I'm 44. It's a little late. I'm not 45 yet. Maybe I can get that waiver still. Anyone happen to know Pete? Anyone happen to have a phone number for Pete Hegseth? I need a waiver. Oh, Lord.
And I'm going to go down all the way down to the conclusion. In that report, is there reference to any company other than Celebrate in this entire report? Is
In
there?
this report, no.
Okay, thank you.
I mean, I am a lawyer, so that probably gets me 02, probably 03. It's not bad. Yeah, I know. Yeah, yeah.
Now let's go to your prior testimony in the first proceeding, where you said that it was important to use multiple tools.
Absolutely.
Do you still stand by your position that you've given today and that you gave in June, that it's important to use multiple tools?
Absolutely.
Now let's go back to the issue of the extraction of Jen McCabe's phone. And what I want to do is to cover a concept and see if I've got this correctly. Are you familiar with the phrase Apple source codes?
I'm sorry, can you please repeat?
Absolutely, no worries, sir. Are you familiar with the phrase Apple source codes?
Apple's,
I could go train at Paris Island in South Carolina. I'm familiar with it. It'll be good. Oh, Lord. That'll be near my parents. That'll be nice. Man.
source code? Absolutely, yes.
And isn't it a fact that Apple keeps its source codes proprietary, meaning very few people have access to it?
That's correct. It is closed source is the term we would use.
Closed source.
That would be the term of art, correct?
And they keep it so close that they call it closed source.
And it's not just Apple. Lots of tools are closed.
Either that, or I can maybe I can get appointed Surgeon General or something. That way I just become like instantly a general. That's nice. Get myself promoted to, what would that be like? What is that, 08, I think, for Surgeon General? Yeah, something like that. Yeah, it should be, I think it's 08. Yeah. So I need a direct commission to 08. That's good. It's what I need in my life. Yeah. Anyone happen to know the Secretary of Defense or the President? That'd be good.
Closed source. That just means that the code isn't available like it would be for the tool I mentioned earlier, iLeap. That's an open source tool. Anyone can look at the code. For Apple, we cannot go look at the code that makes your phone run. That's correct.
And isn't it the case, and I refer to that as the MB postulate, to shorthand it, but I don't need to have you refer to it that way.
I'm sorry, could you repeat that phrase? I was unfamiliar with it.
I'm going to skip it.
Okay,
I'll
thank
just
you.
go on. Basically, the concept that Apple has source codes that are closed sources. So I just refer to them as Apple's closed sources. Wouldn't the best information about when a search occurred, what it's associated with, wouldn't the best information be in the Apple source code to answer that question?
It is acceptable in digital forensic science and in accordance with the NIST Science Foundation papers to conduct testing to determine how the functionality of something works. You do not need access to the source code to be able to speak to an artifact.
My question isn't that. My question is, isn't the best place to go is to the Apple source codes themselves, or are you saying these physical analyzer tools are just as good, and the information they pull is just as good as an Apple source code?
Those are very, those are incongruent statements. Apple source code is not a healthy way to do an examination because it would be so onerous, and we do not know the level of documentation, we don't know the language. That is not necessarily the most effective way to determine what data is. Forensics tools parse results of how data is. They don't interpret them. The examiner interprets them and provides meaning. And I would like to state that those three things should not be conflated. They are very individual concepts.
I think you misunderstood my question.
I probably did it because that's what I was seeing.
My question is this. Isn't the best source for information about data in an iPhone contained within Apple source codes?
Not necessarily. Because that doesn't operational performance is a better source in a practical sense to being able to determine what something is, as opposed to zillions, and no, I don't know the number because it's closed source, lines of code that may or may not have different levels of documentation. Apple themselves wouldn't be able to, any individual there who has access wouldn't know every feature of how every.
I want to see this woman stand at attention. I want to see this woman give a salute. I don't think she can do it. It feels very disrespectful to question someone else's service, but I'm doing it. I'm sorry. It feels incredibly disrespectful to question someone who served for 6 years, but I don't believe it. I'm sorry.
Every element works. Testing through the methodologies described in NIST is the accepted methodology in our science, not reviewing the source code.
I'm going to try it a different way. I understand what you're saying is, if I got it correct, you correct me. Are you saying that these physical tools make it easier to interpret and view the data?
I did not speak about the tools at all in the statement I just made.
Okay.
I spoke about manual testing and checking the functionality and what results. Parse tools, again, these are three separate concepts. The concept of code and actually reviewing code to make a determination is different from parse tool results, is different from doing testing and validation. Those are separate concepts. They should not be commingled as if they equate to each other.
So have you ever learned of, have you ever spoken with Mr. Whiffen? Ian Whiffen?
I have spoken with Mr. Whiffen historically, but not since the term of this trial.
Okay. Have you ever spoken to Mr. Whiffen about whether the Apple source codes are the best source of information about topics like timestamps? Have you ever spoken? That's just a question.
I have not had that
you ever talked to him?
conversation with Mr. Whiffen, no.
Okay, already. I want to move on to, and do you regard Mr. Whiffen as a reputable?
Mr. Whiffen is a reputable forensics examiner, and I've actually reviewed his work in other instances and peer-reviewed his papers.
So you have regard for his reputation?
I have regard for his reputation.
Sorry, we have to wait for each other to talk.
Yes, I'm sorry.
It's all right, no worries. So you have regard for the opinions of Mr. Whiffen generally, correct?
Absolutely, yes.
And you believe he has a solid reputation, correct?
Absolutely, that is correct.
Now let's turn to the History DB database. You are familiar with History DB? History DB, are you familiar with that phrase?
I am familiar with that phrase.
Okay. Do any of the house-long searches appear in the History DB?
In this instance, no, we do not have artifacts in the History DB of either of those two searches.
So I want to just repeat that in a different way. So the History DB, is that considered a valid and valuable source of information in an iPhone?
That is a valuable artifact for Safari history. That is correct.
But the house-long searches we've been discussing do not appear in that History DB, do they?
That is correct.
You spoke about PYF, PDF on your direct testimony. Do you recall that?
I do. It's the Python framework for PDF. It is a GitHub tool, one can download from GitHub to utilize to create PDFs using Python code. So a developer and a tool would integrate that to create a PDF.
And the PYF, PDF can have the variables set, correct?
Yes, the Python script allows the developer to set things such as their name that they created the document, yes.
I want to go to the extraction of Jen McCabe's phone that you talked about on direct examination. Is the hash value signed or unsigned?
A hash value isn't signed. I believe your question you're asking me is if the Adobe document that contained, the PDF that contained the hash values, are you asking me if that's signed? Because a hash value is something that matches, a hash value isn't signed.
Let me ask it this way. Is there any hash value associated with Jen McCabe's phone that is unsigned?
That is not a valid question. I apologize. We don't refer to hash values as being signed or unsigned. We would refer to the PDF that contains that value as being signed or unsigned.
Have you ever read a report of Mr. Ian Whiffen in this case?
I have, but I have to be clear, I have not read all of Ian's reports. I've only read some, so I don't know if I read some of his earlier reports.
Do you recall reading a report of Mr. Whiffen where he
Yeah, a signed hash. The hash is the authentication. It is the signature of the file. It wouldn't make sense. How would you even sign a hash? There probably is some sort of hash that does that, but yeah, you'd have to design it specially. Yeah, because normally you wouldn't. Because part of the hash would have to authenticate that it was created like time, day, simply. Yeah, never mind. Okay. Yeah, that would also mean that. Yeah, so you would need to. In order to have a signed hash, you'd have to code in the signing information somehow into the hash, probably separate and apart from the hash, like you would tack it on at the end, because you need to be able to decode it, which you normally can't reverse a hash. So you'd have to have some sort of, and yeah, I don't know how you would even do that in principle. I'm confused. Never mind. Moving on.
references a hash value being unsigned associated with the iPhone of Jennifer McCabe?
Can I see said report so I can validate if I did or did not? I'm not sure based on just that, because I wouldn't use the term hash value being signed.
Yeah, that doesn't make sense
either. I did
either.
see a report in which Mr. Whiffen spoke to the PDF not being signed.
Yeah, it wouldn't make it signing it. The hash value being signed. That doesn't make sense.
I'm going to try to shortcut this and work off your last statement. You're now saying you do recall seeing a report of Mr. Whiffen where he said a PDF was unsigned?
I need to see. I do remember him.
I mean, the only other way I can think to do that is that like you would wrap the hash in a signature. Like you could do, you could sign it that way. So you wrap the hash in a signature. I'm not sure why you would do that. If you want to prove the hash was generated at a particular time, maybe for some reason. Yeah, you could do that, I guess. Yeah.
And sing the PDF. I would need to see the report, especially since the characterization of hash value being unsigned is not a term of art that I am familiar with in our field.
Let me ask if you agree or disagree with this statement. This value can be used to compare with the original hash calculated at the time of extraction in order to validate the extraction data. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication, but cannot be guaranteed 100%. Do you agree or disagree with
His
that
statement there says the PDF is unsigned, not that the hash value is unsigned.
Right, but it's nonetheless unsigned, correct?
The PDF is not signed. That is a correct statement. Gray key PDFs that purport that value are not an Adobe signed document.
Do you know the history of the extraction of Jen McCabe's phone? It's a
Can,
yes or no.
can you provide more clarity? What do you mean? Do you mean from the time the image was made? Do you mean from the time the device was received? Because I don't know the information pertaining to the receipt of the device into evidence, and then when I only have the documentation of the image forward. So I want to be clear about what period we're talking about.
It's an excellent point, and I am going to follow up with some questions.
Okay.
In an extraction, doesn't the extraction from a phone start with the raw data, raw image? You tell me, when someone brings a phone in, what's the first step that gets taken in order to do a full file extraction? What's the first step?
It depends. There's got to be steps with regard to network isolation. I need to know if the device is AFU or BFU at that point. So I don't have that information from this case, if that is the question. I get from the image forward.
So what I'd like to do, and this may be my last section of questioning, I'd like you to describe the ideal situation as to getting the most reliable data from an iPhone from the start. What's the most reliable way to do it?
I would say the most reliable way is following the recently released SWIG-DE Scientific Working Group on Digital Evidence document on best practices of evidence handling, preservation, and imaging. I may have that title slightly out of order, but it is the document released this January.
And tell me what that is.
Sure. In that, the first thing, from which point are we starting? Are we starting like extracting the data using a tool, or are we talking on scene, taking the device into evidence?
The latter.
Okay. So the first thing you're going to do is you're going to ensure that you are isolating the device. This is also going to depend on condition from the network. So typically this would be done with a Faraday enclosure in a best practice. However, there are alternative ways of isolating from the network, such as disabling all of the communication protocols, such as Wi-Fi, airplane mode, etc. The next step, once you've isolated, but prior to, you also want to make sure you're continuing battery stat. So if a device is on, you want to keep it powered on. If it's off, you want to keep it powered off. That's a general statement. So the best way to do that is to attach a battery charger. Just like when your battery runs low, you plug in a charger in the back of these battery packs. We do that with that before we put it in the Faraday bag. A Faraday bag is an enclosure that blocks signals from coming to the device. This is so a remote wipe command couldn't be sent, or so that more data isn't received to the phone, because phones are live and constantly obtaining data. So we're going to have it with a battery pack in a Faraday, presuming it was on. Again, I don't know the status of this device. The next steps are going to depend on what state that device is, and what make and model that device is, and what the current support for that device is. There are multiple types of extraction methods of phones. In the modern day on iOS, a full file system image, what we had on the devices in question in this case, is considered the gold standard because it has the most robust information. So at this point, the next question is what's the best image type? And that's going to depend on if we have a passcode or if we don't have a passcode.
If I could,
Please.
and I'm going to allow you to continue.
Yeah, please.
I want to break it down for the jury. So what I now want to do, you've stopped at a certain point, but you've talked about securing, what I would call securing the phone, right? And then making sure that there's no data swipes. You talked about airplane mode, Faraday bag, Faraday box, right? Do you know whether any of those protocols were followed for either the iPhone of Jen McCabe or John O'Keefe?
No.
As I mentioned, I was not there for those processes. I don't have documentation of it. As mentioned, what started where my receipt of the device is from the image.
Exactly. So you don't know.
I can't testify to processes I did not or was not available or aware of.
Fair enough. But do you have a little bit of hint as to whether the phone of Mr. John O'Keefe was properly secured in airplane mode, a Faraday bag, or a Faraday box, based upon your own report of the iPhone of John McCabe. Can you determine that from page 5 of your report?
Obviously, there is data signals that are still being made and created. I believe that is what you're referring to. So the assumption is that I don't know at which point a Faraday bag is employed, but I also want to be clear, I don't know when, I don't have information outside of the digital forensics realm about this case, so I don't know precisely when the phone was taken into custody by law enforcement.
Fair enough. So assume that Mr. O'Keefe was deceased around the latest 9 a.m. on January 29th, 2022. Isn't there activity on that phone, health data activity, up to around noon of January 29th?
Health data activity would continue to be reported regardless of if the device was isolated from the network or not. Health data has to do with the movement of the device, so if the device was being moved even within a Faraday bag, that data would still be populated.
How about location data?
Location data is unlikely to be reported in a device that is Faraday enclosed, but I do not know what location data you're referring to, so I cannot speak in absolutes without having a better reference to the artifacts in question. If you're saying it's in my report, I'll look at it, but again, I never knew when the phone was seized, so it was not part of my initial analysis. Do I have permission to look at that time, Meg?
Yes.
Thank you, Your Honor. So, bear with me, it's a big report, as you know,
It is a big report.
and it was at the bottom of my stack.
Pardon me?
All right, it was at the bottom of my stack. I had to lift up the other ones to find it. All right, so.
Your Honor, may I assist and point her to a page?
Sure.
That'd be great.
Thank you. If you could turn to that report on your page 47
Mm-hmm.
and continue on to page 50.
I do see incoming data that is consistent with the device not being Faradayed, such as the receipt of SMS messages, notifications from Ring, et cetera.
So, the iPhone of Mr. O'Keefe was not secured in the manner you described before we got to this, as would be the best practice with regard to getting the most accurate data from a phone. That is, once it comes in, that it's to either be put in airplane mode, Faraday bag, or Faraday box. Is that correct? By your own report, you see activity.
I do see activity. It was not Faradayed. Faraday prevents wiping of the device and additional data. So actually, in this instance, it doesn't appear that the device was at risk of wipe because it was not wiped. And we actually have more data because we get to see the data that continue to come into the device. I'm not saying that's in accordance with best practice. I'm saying that that's what I see based off of what you just had me review in the data.
It sounds like you're trying to justify.
Oh, I'm not
if
trying to
right or
justify.
wrong, you tell me. It sounds like you're trying to justify the fact it wasn't secured. Am I correct? Or
No,
incorrect?
you're incorrect. I'm just stating we have, you asked if we had more data or less data. We actually have more data with it not being Faradayed. But no, best practice would be to Faraday.
That
I
wasn't my
100%
question.
agree.
My question wasn't, is there more or less data? My question was simply, doesn't your own report
Sure.
show activity up until noon on January 29, 2022?
Correct. And for clarity, my scope was till noon, so I don't know if there was activity beyond that.
Right, but as far as your scope goes, I want to be clear.
Yep.
There is activity on
Absolutely.
this phone
Absolutely. The
which
phone-
shows that it was not put in airplane mode, it was not put in a Faraday bag, and it was not put in a Faraday box, and that failure is not best practice.
Correct. It is not in accordance
Thank
with
you.
the best practices. I agree. I would have Faradayed it.
Thank you. So,
If I,
that's
presuming all
okay.
things.
I have no further questions. Thank
Well,
you for
thank God.
answering my questions, Ms. Hyde.
Please
Thank
plead
you
their
for
no
your
to
questions.
redirect. I
Have a
never
good
want to
day.
hear from this woman ever again.
Redirect.
No, please. No, please. Thank you. I'll vote to convict if you don't ask her any questions. I'm ready. I'm good now. Please, let's just not.
Of course.
Whenever you're ready.
Thank you, Mr. Brewer.
You're welcome. You were asked when you began working on analyzing phones in this case, and you said it was in May. Was that of May of 2023?
May of 2023, May 4th, 2023 is the email I have of a note. Thank you. Yes. It's easy to remember because May the 4th be with you.
When you
Oh my
first
God.
were asked to begin
Kill
work
me.
on this case in May of 2023, what was the catalyst for you to begin working on this?
I was contacted by Mr. Tully and then contracted, a SOW was signed, and I began work on the initial request to look at those two search terms on January 29th. Does that answer your question?
Sure.
Okay.
Was there a certain claim that was lodged that you were to focus on?
I was to focus on the two search terms from January 29th, 2022.
And were you informed why? Was there any context to that?
Probably, I don't recall the exact conversation that I had with the DA's office and Lieutenant Tully at that time, but I'm assuming that I was given that context. I have in my notes that I was to look at those two searches on that date and do an analysis about those.
Were you asked to reach any particular result?
No, I was asked to provide my report, not to reach a particular result.
Were you asked to reach a conclusion that the 227 timestamp was inaccurate?
No,
When you engaged in your analysis, was it independent of the district attorney's office?
my analysis was independent of the district attorney's office. I actually, in the first case, had very little communication with the district attorney's office during the period of my analysis.
Was there any
Axiom does not do that at all. They speak to how they recovered the artifact, be it that it was parsed. When I say parsed, I mean the item was where it was expected to be in the algorithm, found it, located it, and said it's here, versus carved, which is when they have to go into an unexpected area, such as slack space, which would be the areas that are not yet used or were previously used to extract the data from that.
So Axiom actually recovers the timestamp, but Celebrite does not. Is that correct? Is that correct?
Yes,
Okay.
currently, previously, when we did the first case.
Right, but currently,
opposite.
Celebrite
Correct.
doesn't, but Axiom does. Axiom recovers 2:27:40 a.m., correct? Timestamp? They
That
recover-
is the timestamp that they show for that artifact. correct.
Exactly. So now I'd like to go back to the next topic, our discussion about Mr. O'Keefe's phone and secured or not. You talked about one example of maybe needing to use a biometric to unlock a phone, and that might be a reason, as I understand it, as to why someone might not put it in a Faraday bag or box. Do I have that correct?
Correct.
Okay, do you know whether the passcode was immediately provided on the phone of Mr. O'Keefe?
I do not have that information.
Assume that the passcode was immediately provided for the phone of Mr. O'Keefe. Can you think of any other reason why that phone wouldn't be put in airplane mode, Faraday bag, or Faraday box?
Best practice would be to put it in a Faraday bag.
Okay.
Sorry.
And that phone was obviously not put in airplane mode, Faraday box, or Faraday bag after 6:04 a.m. on January 29, 2022, correct?
Correct.
Now let's go to,
Well, I don't know if at some point past 12 o'clock. My report only goes to noon, so just for clarity, I don't know
Fair enough.
anything past noon.
fair enough, but from 6:04 a.m. until approximately noon on
Correct.
January 29, 2022, at least that time, that phone is not in airplane mode in a Faraday bag or a Faraday box, correct?
It would appear such. Because I didn't analyze past that, I don't know if it had been potentially Faradayed and then it broke Faraday and got data, but I don't suspect that based on this. It appears that that data was live. But I just have to speak to the fact that I just don't know because I didn't go past noon.
Right, but you're going past noon.
Right.
I'm not.
Okay,
My
yeah.
question,
6
and
a.m. to
I'm,
noon, it does not appear to be Faraday.
so to be clear, from 6:04 a.m. on January 29, 2022, until at least noon of January 29, 2022, the iPhone of Mr. O'Keefe is not in airplane mode, it's not in a Faraday bag, and it's not a Faraday box, correct?
Unless it was in a broken Faraday bag, like they put it and it was failing. But yeah, it does not appear to have been placed in Faraday bag.
All right.
Well, I'm just being honest. You should test your Faraday bags. They go bad. I use Dr. Katz's testing methodology, but 100%, it appears to have been receiving signal for that entire period and not in a Faraday bag, which would be best practice unless biometrics were needed.
So let's now go to hopefully what are the last two categories of questions. With regard to the iPhone of Jen McCabe, do you have any knowledge as to whether over 200 calls were auto-deleted on her phone? You analyzed it.
We can see that calls were auto-deleted. You're asking me if the number of, I just want to make sure I understand the question. If the number of calls that were auto-deleted, if that exceeded 200?
My question is, do you know whether there was auto-deletions on Jen McCabe's phone? Do you know that?
I'm uncomfortable with the term auto-deletions because
How
I
about
don't know
deletions?
what that is inferring.
Okay. Did you analyze her phone at all for deletions?
I analyzed her phone to see if there had been deletions of call logs, and what I found was that there were records that were removed by the system and not recoverable from that database, but were recoverable from biomes.
Understood. Now, what I'd like to do is to address your answer in response to Mr. Brennan's questions, where you said that the issue with regard to Mr. O'Keefe's, or just generally your proposition, that there was no impact on your conclusion because more data had been obtained. Did I get that correct?
I believe my statement was there was no impact on my conclusion with the fact that it had not been in a Faraday.
Right. So isn't it, though, the case that when a phone's not in a Faraday and is therefore active, data can be overwritten?
Yes.
So if data can be overwritten when it's not in a Faraday, you can lose that data, correct?
Is there data that we're concerned? Yes, theoretically.
Right.
Yes.
You talked about, in response to Attorney Brennan, the 12/31/56 steps, and you said the last, according to you, last movement, 12/32/16. Do you recall those questions?
I recall the questions.
Yeah. To boil it down, isn't it correct that that phone was moving at that time?
May I check the timestamp again? I
Absolutely.
apologize. There's
Oh, no.
a lot of timestamps going back and
Please
forth.
do.
12/31/56? Is that
Yeah,
the?
that's the start, yep.
Oh, yes, this one there definitely is. Yes, yes, yes.
So, doesn't matter what kind of movement, but that phone was moving starting at 12/31/56 and still moving until 12/32/16 a.m. on January 29, 2022, correct?
Yes.
Thank you. Appreciate again your answering my questions.
Thank you.
All right, Ms. Hyde, you're all set.
Thank
Thank
you,
God.
Your Honor.
It's over.
I see counsel about scheduling.
Yay!
Stand up and stretch.
It's over. Yay. We don't have to hear from her anymore. Yay. Exciting. Now there's some sort of scheduling thing. I don't know what they're doing. Let's see. Today's Wednesday. So, yeah, no, whoever said Proctor was on today lied. Someone from Proctor's in the building. Yeah, well, no, not so much. So let's see. When are they going to do Proctor? It's hard to believe they call him tomorrow. Doesn't make sense. Calling him Friday might make sense. You can keep him on direct long enough to go through the weekend. You don't want to start on cross, have cross going over the weekend, I don't think. I think Proctor first thing Monday probably makes the most sense. You finish up by Wednesday.
May I?
Have a couple days to finish it off,
I would
and
like to play clip 15, please.
no, they're not going to call him today. The day's over. It's 3:30. The day's over. They're not going to call him. I don't know what they're doing for the rest of the day.
Absolutely love Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Okay. All right, so folks, I talked to the lawyers briefly about scheduling at sidebar, and I'm told we're actually ahead of schedule. So with that, rather than beginning a witness who's probably going to take a while, we may as well let you go and enjoy the rest of this beautiful afternoon. So we're on schedule, ahead of schedule. We'll reevaluate that tomorrow, and I will see the lawyers at sidebar as we do as well about to talk a little bit about scheduling. Those same cautions, please. Do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know, and be very careful with your social media use. We'll see you tomorrow morning. Thank you.
All rise to the court, please. Close your notebooks and follow me.
Yeah.
Why don't you come on up?
I don't think it makes sense to call Proctor tomorrow. Because, like, you don't really want... Yeah, because the problem is you never be done with him. Even if you called him first thing in the morning, you couldn't really guarantee that you'd be completely done with him by the end of the day Friday. Is Friday a half day by any chance? Either way, it wouldn't. Either way, you couldn't guarantee it. But is Friday a half day? If Friday's a half day, really, then you are really in trouble. So, if Friday's a half day, maybe you call him. Yeah. If Friday's a half day, maybe you call him first thing on Friday. You can guarantee that he's going to be on direct through the end of Friday. Yeah. Maybe you call him first thing Friday morning. You have 4 hours. You can guarantee you can keep him on direct for 4 hours. So that gets you through the end of the day. You pick up direct on Monday with whatever's left, and then cross. Yeah, so maybe you call him first thing on Friday morning. That might make sense. Or you call him first thing on Monday. And then it's just a question of, like, if you call him, and that's just a question of which of those things makes more sense. If you call him first thing Friday, you take the half day on Friday. You finish him up, say, early Monday. Then you pick up cross maybe Monday at the mid break or Monday at lunch. That gets you Monday. It gets you the rest of Monday through cross. He finishes up on Tuesday, and then you have 3 days to, like, rehabilitate with whatever other witnesses you have to sort of wash the memory out of him. If you wait till Monday morning to call him, you don't have as much time in the week before the weekend. So, yeah, probably. I don't know that I'd call him tomorrow morning. That doesn't make sense. I don't think I can keep the direct going for a day and a half. I don't know how I keep the direct going that long. And I don't want cross. Well, do I want cross to start before the end of the weekend? I mean, probably not, because they're going to start with, like, aren't you a disgraced trooper? That'd be the first question on my mind, and leave the jury resonating with that. I'll make sure that if I get cross on Friday, I'm going to ensure that the last question I ask before they break for the day isn't, "Aren't you a disgraced trooper?" Leave that, I'll ask it when they first start and then ask it again, but before they leave for the day. Yeah, so I don't think they call them first thing tomorrow. So first thing Friday or first thing Monday is probably the most logical thing. So they got to figure out who else they're calling tomorrow. Yeah. Call them Friday morning. Call Friday morning, do a half day, finish it up on Friday. Cross, redirect, finish it up by Tuesday. And then you have 3 days to rehabilitate with whatever you've got to work with. Full days all week, next week? Okay. Do I think Proctor's testimony or conduct will be any different? A little bit. It'll be a little bit more polished. And the state is probably, and I mean, with him being, kicked off the force, that definitely inspires some additional questions. So yeah, if I'm the state, I definitely have to that is a problem for me. I have to really at some point I have to mention the fact that he's discredited. And so when do I do that, right? Do I do it? Yeah. Do I call him to stand Friday, just ask sort of normal questions about his investigation, and then do first thing on Monday, by the way, you're discreet. Then by the way, you're kicked off the force, because I don't want the jury to know that before they go for the weekend. So that probably is the way to go. Friday scheduled as a full day. If Friday is a full day, then same analysis. I just call Proctor after lunch and get him started. Yeah. Then I just need witnesses for a day and a half. So I try to finish up whoever I have, by lunch on Friday, and then I call Proctor first thing after lunch. Mention the fact he's disgraced early Monday morning, and hold on for the ride. They said on Monday they'd wrap up around 11 a.m. on Friday. What, the entire prosecution case? That's not possible. They have a lot more. The prosecution's going to be done on Friday? I don't think so. AJ told the jury about being fired, an opening statement. Yeah, I know he told the jury that. I understand that. He told the jury about that. I'm well aware of that. But I don't want that being a lingering thought as they're going through the weekend. That the fact that they heard about during opening is yesterday's problem. My problem today is I don't want them thinking about it throughout the entire weekend. The fact they've heard it before is not, doesn't change the analysis very much. They'd be done for the day at 11 next Friday. Oh, well, we'll see how it goes. Yeah, that makes sense to me. Call them Friday, keep them on direct. Call them Friday, keep them on direct. Resume direct Monday morning. Bring out the fact that he's a fired cop. Spend time with that. Linger on it, because the defense is, so you're gonna have to spend some time on it. And you're gonna have to spend some good quality time there as the prosecution, probably longer than you really want to. You can't blow by it, because that just defeats the point. So you're gonna have to spend some quality time talking about what a disgrace he is for a hot minute to try to take everything out of the defense's sails. They're still going to do it anyway, but you want to try to take as much out of their sails as you can. So yeah. Yeah. So I think that's where we're sitting. That makes sense to me. Yeah, I think that makes sense. Then you finish up with your medical. Then you finish up with the rest of the police. You finish up with medical testimony. Yeah. So then after Proctor, you call, the remainder of your cops. You call your medical examiner. You call your dog bite expert. You finish with Aperture, and you call it a day. And I hope for the best. I think that's what makes sense. I think that's what makes sense. All right. Can the defense ask Proctor why he's fired? I'm sure they'll figure out some way to ask the question, yes. So, yeah, one way or another, it's coming out. I think as the prosecution, you just have to bite the bullet. I think you have to bite the bullet.
Thank you. I'll see you tomorrow morning.
Yeah.
You have to sign my signature.
Yeah, that's my first instinct, and it could be wrong. My first instinct is, as the prosecution, just bite the bullet. Just do it. Just rip the Band-Aid right off. Don't fight it. Don't dick around on it. Just get out in front of it in the open. Just say all the things. Don't dick around on it. Just put it out there yourself in no uncertain terms. Don't try to shade it. Don't try to hide it. It's not a fun happy position as an attorney, because normally fun happy position is, you try to elevate what's good and you try to diminish what's bad. That's sort of like job one from the attorney. One of the job's fundamental roles is to elevate the good and diminish the bad. And here I'm basically like, yeah, I kind of have to do the exact opposite of that. Here the right move. Here the right move is to elevate the bad, is make it as bad as possible, because the defense is, so I might as well, because I'm trying to draw the sting. So in this case, elevation requires me to just bite the bullet and bite it hard and suck it up like a little bitch and see what happens. Yeah. That's my instinct is. Because if I get out in front of it and I just put a spotlight on it, and I, put a spotlight, look at the clown, look how corrupt the clown is, look how super duper corrupt it is. It builds credibility. It has the advantage of building trustworthiness in the jury, because the jury sees that I'm, showing them the thing that's ugly. So it builds trustworthiness. It takes the wind out of their sails. And the worst the defenses can do is just basically do what I already did. So they can't really go anywhere because I already did everything. So my first instinct is, fuck it. Fuck it. Just fuck it. Let's go. You sure you can ask all the questions, but not before I do first. It's one of those sort of things from the movie. It's like, you can't shoot me, I'm going to shoot myself. It's one of those deals. You can't fire me, I quit. That kind of deal. Yeah. Basically, it's just you just go, you're like, fuck it. Let's just steer right into the skid and hope for the best. So that's what you do, I think. I think that's the right thing to do. You call Proctor. You don't do the fact that he's disgraced before the weekend. You don't want the jury sitting on that. You mention the fact he's disgraced Monday. You spend quality time beating Proctor to death yourself. Spend half a day just beating him to death yourself. You turn over to the other side. They beat him to death for a while, but it's okay. Then you bring on the rest of your police that you need to bring on. You bring on your medical examiner. You bring on your dog bite and other medical experts. You bring on Aperture, and that is the case. And anyone else that can help you testify, anything else that would help you with terms of your strongest evidence that's left that this happened. Probably your dog bite expert, and probably your Aperture is probably the strongest. If the prosecution doesn't call him, do I think the jury will take as they're trying to hide it? Well, if the prosecution doesn't call Proctor, the defense almost certainly does. And then the defense is the one that gets to like reveal all the nasty things. You see, if you have bad information as a lawyer, you kind of want to get ahead of it because you know the other side's going to, and they are of course doing what they're going to do. They are of course going to reveal it in the worst possible way. That is their mission, right? That is their goal. They're going to take this bad thing and they are going to make it look as bad as they possibly can. They are going to reveal it in the most sinister, shitty way that they can possibly dream up, because of course they are, right? So if you don't do it, they're going to do it for you, and they're going to do it in the most uncomfortable, ugliest way that they can dream up. So so therefore the only thing you can do really at that point, if you can't stop them, which I'm not sure you can, if you can't stop them, then the only other thing you can do is do it yourself first. But you can do it with more control. It's still ugly, but not quite as ugly. So you can say everything is substance, but you make it look more honest, because it's just an admission, right? At that point, just like I'm a dirty person who said some horrible things about, and I'm a disgrace to everything and everything good around me and all the rest of it. So you have a little bit more control over it, about how and when, and so you get to present it. You get to present the shit in a better light, Yeah, but if you don't do it, the defense almost certainly will, and they're going to make it very unpleasant for you. So you kind of have to, I think. I think you have to call Proctor. I don't think there's an alternative. It's like, how can you not call Proctor? How's that work? It doesn't work. Yeah. Yeah. So you call Proctor to the stand. You walk him through all the good he did on Friday. Then on Monday, you beat him to death in front of the jury. Then, then the defense beats him to death, but it's okay because you did it first. And then you move on with the case and hope everyone forgets about it somehow. And finish as strong as you can. Yeah, that's probably the best way to go about this. It's not like it's a great plan. It's just the best of all the available plans. It's like, this plan sucks. It's just that there is no better plan. You see, this is the thing. Like, I have nothing but bad choices. And that's sometimes a position, of course, a lawyer's in. You can't control everything. Sometimes you have nothing but bad choices. And then it's just like, well, how do I make it the least bad? So this seems like the least bad. Is it bad? Yes, but it's the least bad. So I can't think of a better way to go about it. Maybe someone, to be fair, these guys have a lot more criminal experience by far than I do. So if they have a better idea, I'd love to hear it, but I don't know what that would be. I don't know what a better idea is. The plan sucks because the case sucks. Yeah, it's like I can only do so much with what I have, right? I have to, unfortunately, deal with the reality of the situation. So you might as well open the curtain. You might as well open the curtain and let them see the ugliness. If you put on the right kind of lighting, though, you have to put a spotlight on it, but maybe you can put a lime light on it, so it won't be so bad. You have to spotlight it, but you can put a lime light, so it's going to be okay. So you make the monster look not so scary. That's as good as it gets, I think. I got no better plan than that. So, as the Commonwealth, I've got nothing better. Yeah, Trooper Paul's not coming back. We have his boss or his mentor, I think, from the police station. So we have his mentor, and then we have Aperture, I believe. Yeah. And, if fate is kind to the prosecution, that is a winnable case for them. They're on they're on a path to having a winnable case. I think much more so than last time. Proctor is a deficit, but he was already a deficit. So he's a slightly bigger deficit than he was last time because he was dishonorably discharged. But, they've shit sandwiched this. They've tactically presented this as good as can. They started strong, at least in my opinion, with, I hit him, I hit him, I hit him. You had all those witnesses front loading the, confession. You backload it with, the medical examiners that will say that this was a dog bite or not a dog bite. You back end it with Paul's boss. You back end it with Aperture. So you start strong and you end strong within the constraints of the case you have to work from. Everything else goes in the middle, and then Proctor basically winds up in the middle of the middle. So he's the middle of the shit sandwich. So, and that makes sense. So within this confines of the shit, you start not as shitty and you end not as shitty, and in the middle is the shittiest of it. And you hope primacy and recency take over, because that's a pretty good reason. That's a pretty good thing to bank on. So you just lean on the confession. You lean on the physics that you have that backs this as a thing, and you sort of forget everything else. That's the play. And if fate is kind to them, if fate is kind to them, that is a much better position than they had the first trial. So their odds of conviction, I think, are going up relative to the first trial. And then, of course, during the rebuttal case, you bring on Aperture again, or whoever it is you need to bring on to rebut Arca, to emphasize the physics again. You put it all together with a closing speech where you emphasize the confession. You emphasize the confession. You emphasize the medical stuff that you think backs you. You emphasize the physics you think backs you, and you sort of gloss over everything else. The defense, hammers reasonable doubt, because of course they do. And I'm not quite sure what you do in terms of the rebuttal close at that point. You could, for example, even go so far as to hold the I hit him from your initial close and save it for your rebuttal close. So you just bring in you sort of gloss over the investigation. You gloss over the parts that are uncomfortable. You talk about the taillight pieces you supposedly found. You talk about, all the evidence that helps you without bringing attention to the bad parts. So yeah, that's a good idea actually. So your close is talking about the police investigation, but just the aspects that help you. And the medical stuff that helps you. The defense close then is, reasonable doubt, based on Arca, for example. And then the state's rebuttal close is talking about the confession. And you play maybe some clips of Karen Reed in her own words. You drop the hammer, and you're well on your way to a conviction. You're well on your way to a conviction. And then it's only a question of, at that point, it's obviously I'm trying to anticipate based on the first trial what the percentage chances are. But right now, as I'm forecasting it all in my head, trying to project, what the odds are for the prosecution. Because battles of experts can be a wash. The fact that Arc is a hired gun is obvious. You have the police who say it happened. You have the police, mentor of Paul, who's going to get up there and tell you why it happened as a matter of physics. You have the hired guns and our Aperture who will tell you why it happened as a matter of physics. You have the confession. Juries eat that shit up. I think I know it's not a popular opinion, but I think at the moment you have to you're trying to guess how things are going to play out. You're trying to sort of speculate how they're going to play out. But I think that the odds favor conviction. I don't know if necessarily on murder, but their manslaughter conviction's looking pretty damn good right about now. And I think they have better than even money on a conviction on a murder count. Yeah. So I think the odds favor the prosecution in the end if everything goes in my head like I think it's going to go. Yeah. I think the odds probably favor a conviction. The fact that it's a police officer that's dead also juices the odds quite a bit. I think as a matter of practical reality, no one likes a police officer being dead. Someone's got to be punished. Karen Reed is convenient. If not guilty, why guilty shaped? Odds of a conviction right now, probably 2/3 or better. Yep, that sounds about right. Yeah, that sounds vaguely correct. 2/3 or better for a conviction, probably by the end of this thing. Yep. That sucks balls. Of course, if she's acquitted, I'll be ecstatic. So I'd love to be proven wrong. But the confession, man, like juries just eat that shit up. They absolutely eat that shit up. They love that. They love confessions so much. There's more than enough evidence for a reasonable person to conclude that she said it. Now, I think you can excuse it away, but you have to excuse it away. You have a dead cop, the jilted lover. She did it in a fury and a rage, blinded by her jealousy, not even fully aware of what she's doing. Murder too, baby. Yep. And then appeal. Appeals are for losers. Your best argument on appeal is bias. Good fucking luck. And beyond that, I'm trying to think of any obvious issues on appeal and nothing's coming to mind. Pro gamer, am I okay? I seem depressed. First of all, I'm fine. I'm just tired. It's been a very long day. But I'm fine. But thank you. Pro gamer for $25. Kurt, what do you think would happen on appeal? If the Commonwealth continues persecuting, how would not be the best option for Karen? How many mistrials can her and her team withstand? Thank you. It's Sue Candrel. Yeah. Her best, on appeal, if she's convicted, she has bias as an argument, but good luck. Proving bias is, I believe it. I certainly believe it, but proving that legally is incredibly challenging. And no other grounds of appeal really work, or they're not very strong at least. Removing that juror from the initial jury, she was a little sloppy about it, but not in a reversible way. What else would you appeal on? Assuming she doesn't limit ARCA in any way. If she limits ARCA, or restricts ARCA, that would be a grounds of appeal, but I don't think she's going to do it. So unless she does that, it's not a grounds of appeal. What else is there? Like any evidentiary issues, but most of the evidentiary issues have been cured by the second trial. Like any Brady problems from the first trial have been cured. Certain evidence wasn't necessarily preserved, but it's not clear that it had to be. And it can't be turned over now in any event. So Brady probably doesn't work. Most of those problems have been cured. What else? Yeah. I don't know what else you have to work with, really. A defect in the jury instructions for the second jury, but the judge is going to go over those with a fine-tooth comb. I wouldn't bank on that either. If the prosecution somehow goes wildly off the rails in closing or something, but I doubt they're going to do that. Yeah. Yeah. Yeah, I think also with the depression, I think, or seeming depressed, I think also I'm very cognizant of the fact that I'm telling people what they don't want to hear. I'm very cognizant of the fact that, I'm telling myself what I don't want to hear, for that matter. I don't even want to hear what I'm saying. Because I think this prosecution is bullshit. You guys know that. So it's not even that it's not that I know you don't want to hear it. I don't even want to hear it. But that's part of it. It's like, if the jury found AJ overly aggressive and bullying, that obviously hurts the odds. Yeah. Thanks, Bama Law. Yeah, appeals are hard. Civil's more my bag than criminal. And when it comes to that, civil's more my issue than criminal appeals. I don't think reasonable doubt exists concretely. I don't even understand the question. Do I have reasonable doubt? Of course I do. But what is the jury going to do? I mean, the confession goes a long way, guys. It goes a long way. Long way. In terms of why the prosecution gets to keep offering the clips when they do, there's some sort of agreement relating to that. The defense isn't objecting through their presentation. So even assuming it's a problem, the defense isn't raising an objection. So why not? The prosecution can do it because the defense doesn't seem to care. I'm not sure whether or not that's due to agreement or whatever, but the defense isn't objecting to the clips being offered without a witness on the stand. So they seem to be okay with it. For whatever reasons, they seem to be okay with it. I think that the prosecution has been laying things out brilliantly with the use of the clips. I think the presentation of the clips has been incredibly effective. You just bring in these clips piece by piece, drip, 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 drip. You just sort of interlace this confession sort of over and over and over and over. The animus, the motive, the confession, the anger, over and over and over and over and over and over and over. Drip, 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 drip. Pretty damn effective. Pretty good. Yep. The jury will be instructed to find her guilty beyond a reasonable doubt. I'm well aware. It seems to me the case inspires many reasoned doubt that the jury may see. It should. But it won't. Yeah. Juries are scary things, man. 10 euros from Programmer. How do I think people would react to a guilty verdict? Well, I think that they would react the way they're reacting now. There are some number of people that would be very happy about it, and some number of people, perhaps more than that, that would be incredibly unhappy about it. But that's true in either event. If she's found acquitted, that would be true. If she's acquitted, that would be true. So, except, of course, in reverse. Where's the confession I'm alluding to? If you're not seeing it, I don't know what to tell you. You're not paying attention. You are not paying attention. I hit him as a confession. The evidence that's presented, there's more than sufficient evidence. The evidence of the motive, the anger, the animus, the hatred, the phone calls, the voice messages, the interviews. It's there, man. It's there to be seen. It is there to be seen. Where's the evidence? What I just said. I can't give you an answer beyond that. That's the situation. Yeah, there's more than enough for confession. See it with much less. Yeah. 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 Yeah, I mean, Bama law, I assume, will back me on this point. Juries absolutely eat up confessions. They eat them up to, and often seemingly including evidence that seems to flatly contradict the confession. I'm sure Bama law is as aware as I am that there have been convictions on the basis of so-called confessions, wherein eyewitness, physical evidence, etc., and so forth, all go against, right? So on the one side, we have the supposed confession. On the other side, we have the physical evidence, the blood, the DNA, the fingerprints, the alibi, the cell phone data, the tracking data, photo, video, eyewitnesses who put who put the assailant in a different place at a different time, people who will absolutely swear under oath, reputable people who will swear under oath. Yeah, no, the bad guy, no, they were with me the entire time. They were nowhere near the crime scene. Bama law, I assume, is as well aware as I am of cases that are this lopsided, and yet the juries will believe the confession in spite of their own eyes. I'm not wrong. They eat the shit up. They eat the shit up. They eat it for breakfast. It's like their favorite thing in the world. Reputable eyewitnesses, no, he was nowhere near that. He was with me in a different state at a different time. Cell phone data, no, his phone, he made a call with his phone. We know exactly where he was. You know, it's like there's no DNA of his anywhere on the scene. You know, there's no blood. Yeah, you know, they will believe confessions in spite of overwhelming evidence to the contrary. It's not like it always happens every single time. It's not a guarantee, but it's been known to happen. It's been known to happen, and they eat that shit up every day of the week. I mean, you know, on any given day, at any given trial, it might not happen, but it has happened. It can happen, and it certainly might happen here. You know? Yeah. Just ask the Innocence Project about it. Don't take my word for it. Just ask the Innocence Project about it. How many people have the Innocence Project gotten out of jail who confessed to the crime? I'll give you a hint. It's not an inconsequential percentage. Yeah, you don't have to take my word for it. Just ask the Innocence Project. How many people has the Innocence Project successfully gotten out of jail wherein there was a confession from that person saying, I did it? How many cases? It's a big number. It's a lot of the cases. Juries eat the shit up. They eat it every day. Did Karen confess? If you believe the statement, I hit him, she did. That's a confession. I hit him as a confession. If you believe it, and we've got multiple witnesses who said she said it. We got what, 4 or 5 people who said she said it? That's more than enough. 1 is more than enough, to be honest, but you got 4 or 5 people, man. Yeah, no problem. Every day. Every day, man. Every single day. No, she asked. That's not what some of the witnesses said. Some of the witnesses said it as declarative. There are like 4 or 5 witnesses in this case who said she said it as a declarative. That evidence exists. It's on the record. I know. We watched it together. Yeah. It's not good news, man. It's not good news. It is bad news, my friend. You know, obviously something could change in the picture between now and the end, because you know the game hasn't actually been played. I'm projecting what will happen, you know, based on what has happened so far and based on the first trial. It's a pretty reasonable projection, but you know, something could obviously change the mix in a substantial way, presumably for either side. But you know, this feels like the direction we're heading. Everyone heard her confess and she wasn't arrested? Apparently. Yeah. Yeah, apparently. Yeah. Yep. Yep, that's apparently what happened. Yeah. Yep. Yep. I think it's very likely. Well, it's going to be a lot is going to factor into the strength of the state's cases. A lot of this equation is a bit of an unknown because we haven't heard from Aperture yet, and we haven't heard from Trooper Paul's supervisor. So we haven't heard from these witnesses yet. So I'm just like forecasting, like, you know, they probably found some people that can, you know, at least apparently go toe to toe with Aperture. I mean, otherwise, why spend the time? So, I'm giving the state, credit for things that hasn't happened yet. They didn't even happen in the first trial. But, if I were the state, I would have found someone who could go toe to toe with Aperture, or at least apparently so. And so I'm assuming that the expert witnesses relating to the physics is a wash, which seems like a reasonable assumption. It's an assumption, but it's a reasonable one. You bamboozle and confuse them. The jury, just dummy dumps it all because they can't deal with the complexity. Simplifies it down. Bad mojo. It's a bad moon rising, man. It's a bad moon rising. We will see, man. We'll see. Yeah, assuming that the state's physics evidence is comparable to ARCA. And assuming that they've flushed out their medical evidence, then the state is an odds-on favorite, 2-3, maybe a little bit better than that. Yeah, we'll see how it progresses. But on the plus side, you do need a unanimous jury. You got that going for you. But group dynamics are what they are, and they can turn on you in an ugly way too. And we've seen that before. Remember from the ice cream guy. First jury was 11-1 to acquit. Second jury 12-0 to convict. How do you go from 11-1 to 12-0 the other way around? Dynamics, man. Group dynamics are scary things, man. Well, yeah, and then do they put her on the stand? I mean, probably not. I can't. Yeah, I mean the wisdom is not to put the defendant on the stand. I mean, you make yourself very vulnerable by doing that. Yeah, I think the odds of the defense putting the defendant on the stand are basically incredibly low, essentially zero. Yeah, a lot more problems. If you're losing 70-30, is it worth a shot? Not if it changes your odds for the worse. Yeah, you're saying if you're 70-30, is it worth it to roll the dice? I don't know, man. I don't know. I think it makes your odds worse. Yeah. I mean, a lot is then riding on her being incredibly likable. If she comes off as defensive, if Brennan can make her defensive or cagey or, anything like that. Yeah. I don't think it's a good, I would recommend against. The odds of conviction or conviction of all counts, well, that's one and the same thing, really. conviction of at least manslaughter, if not murder. Yeah. I mean, yeah, there's no difference. No one cares about the third count. No one fucking cares. I guess you care if it's the only thing you're convicted of, but that seems unlikely. All right, guys. Well, I'm going to sign off. I will see you guys tomorrow. Tomorrow's Thursday, so we'll have an interview with Turtle Boy. It should be interesting in the evening. I'm taking the day off. I'm taking the rest of the day off. Uncivil's tired. I will see you guys tomorrow. I've been Uncivil Law. Thanks for joining me. Sorry for having a bit of a downer at the end. Love you guys. I will talk to you tomorrow.